Hello. Hello. Good evening, everyone. Comment if you can hear my voice. If you can hear my voice, please comment. Am I audible? Okay. So today we are going to discuss the constitutional bodies. Now, constitutional bodies means that till now we have discussed the union legislature, executive, judiciary, the state legislature, executive, judiciary, and we have also discussed the local self-government. So, we have discussed all the three levels of government and all the three facets of government, all the three organs of government. So, now we will discuss some other constitutional bodies which are separate from these legislature, executive and judicial organs, but they are there because they are autonomous bodies. They are autonomous because they are there to carry out certain specific tasks. For example, there is Election Commission of India to conduct elections. Then there is Controller and Auditor General to conduct the audit of accounts of the central as well as state government. So these agencies are not specifically a part of any of the organs of government, but they are autonomous agencies and they have been granted constitutional position so as to make them very powerful. So the first constitutional body that we are going to discuss is the Election Commission of India. This is the first body that we are going to discuss. So, in Election Commission of India, first of all, the provision is provided under Article 324 of the Constitution. Under Article 324 of the Constitution, and it is a common body. Common body means it conducts elections both for the center as well as the states. Now you might wonder that there is a state election commission for every state as well, but the task of the state election commission is for the local self-government elections that we discussed yesterday. Under the 73rd and 74th constitutional amendment, all the bodies that are mentioned, the elections to those bodies are covered by state election commission, but the Election Commission of India undertakes 6 types of elections. And those elections are: number 1, the President of India; number 2, the Vice President of India; number 3, Rajya Sabha; number 4, the Lok Sabha; then number 5, it is the Legislative Assembly of the states, and number 6 is the Legislative Councils of the states. These are the 6 elections that are maintained and held by the Central Election Commission or the Election Commission of India. Other than these elections, any other elections, they are undertaken by the state election commissions, that is the Panchayati Raj institutions and municipalities. So this is a very important aspect from your MCQ point of view. They generally tend to ask that which one of the following elections are or are not held or organized by the Election Commission of India. So these are the 6 types of elections that are undertaken by the Election Commission of India. Let us see the composition of the Election Commission of India. So, Election Commission of India composition, that means how many election commissioners on central election commissioner are there, is to be decided by the President of India. That effectively means that it is to be decided by the central government. So, the President, as he decides, right now we have one chief election commissioner and two other election commissioners. If you know the name of the chief election commissioner of India, let me know in the comment section. Tell me in the comment section who is the chief election commissioner for India. So, Mr. Sunil Arora is the Chief Election Commissioner of India. Mr. Sunil Arora is the Chief Election Commissioner of India, and very importantly, they are appointed by the President of India. So, the Chief Election Commissioner and the other election commissioners are appointed by the President of India. Excuse me. Another important aspect here is that although it is a 3-member body and it has one chief election commissioner and 2 election commissioners, as far as their powers are concerned, they have equal powers. These 3 election commissioners have equal powers. So, the chief election commissioner does not have much primacy over these 2 election commissioners, and any decision is to be taken by majority. That means if there is a dispute on some particular topic and there are the 2 election commissioners are on one side and this chief election commissioner is on the other side, the 2 election commissioners will win or the majority will win. Therefore, as far as their powers are concerned, they are almost at an equal footing. To maintain the independence of the Election Commission of India, there are various measures that have been provided under the Constitution of India. So, to maintain the independence of the Election Commission of India, there are various measures that have been provided under the Constitution. If the Chief Election Commissioner is to be removed, it has to be done in the same manner as that of a judge of Supreme Court of India. And that procedure we discussed when we discussed the Judges Inquiry Act 1968, that if a judge has to be removed, a resolution has to be moved in either House of Parliament. If it is Lok Sabha, it has to be passed by 100 members, and if it is Rajya Sabha, it has to be passed by 50 members. Thereafter, it may or may not be accepted by the presiding officer of that particular house, and if it is accepted by that member, then there is voting in that particular house, and if it is passed by a special majority, then the resolution goes to the second house, and if it is also passed in the second house, then it goes to the president for his assent, and only then a judge of Supreme Court can be removed. The same procedure applies in case of the election commissioners of India and the chief election commissioner. This provision has been done because electioneering is a very sensitive issue. It ensures that the democracy stays there in place. So, in order to save the election commissioners and the chief election commissioner from any type of pressurizing or any type of, you can say, influence by the government, this procedure has been adopted so that they can be provided with security of tenure. So, to ensure their security of tenure, this particular provision has been provided. The grounds on which a chief election commissioner or election commissioners can be removed are 2. The same grounds, that of proved misbehavior and incapacity. These are the 2 grounds on which they can be removed. No other ground can be specified as such. Similarly, there is also a provision for regional commissioners. There are election commissioners, but there can also be regional commissioners. which are temporary in nature, RCs or regional commissioners, they can also be appointed by the president if they are required in consultation with the election commissioners. So, there is a CEC, then there are 2 election commissioners, then there can be as many number of resident commissioners as there can be. But for the appointment of election commissioners and regional commissioners, the government has to consult the chief election commissioner, and this is where the role of chief election commissioner comes into picture, that for appointing the election commissioners and the regional commissioners, the chief election commissioner has to be mandatorily consulted by the government of India. In all this process, there are certain loopholes. When we are discussing the Election Commission of India, there are certain loopholes in that. In this particular process, we are discussing Election Commission of India. So there are various flaws in this particular. The role of regional commissioner, it can be he or she can be appointed for a particular region. If there are elections in a particular region and the election commissioners do not seem to be handling the workload, so in that case regional commissioners can be appointed. A regional commissioner can be appointed for a particular state election, he can be appointed for a particular you can say Lok Sabha election also. They generally fill in the deficiency of election commissioners. So if these 3 feel that there is a deficiency of manpower, then on a temporary level the regional commissioners can be appointed. That is, this role is as simple and similar to that of election commissioners. There are certain flaws in their process of selection as well as their independence. First is, no qualifications have been prescribed to become the election commissioner or chief election commissioners of India. Although practically all the election commissioners and chief election commissioners that India has seen have been men of integrity, have been men of high intelligence, most of them have been retired IAS officers or senior IAS officers, but the point is that no specific formal qualification has been prescribed for them. So it totally depends on the government. All right, I will now write in this particular place so that it is visible to you. So this is just Election Commission of India written, so it is not a problem. So the flaw in the process is that the qualifications have not been prescribed for them. Therefore, it is on the whims and wishes of the government if it wants to appoint someone who is not fit to hold this particular office. Secondly, the term of members is also not specified. The term is also not specified, which is a big flaw. The retiring election commissioners are not barred from taking up any post-retirement appointment with the government or with any other agency. So this is a big flaw. It is already under, you can say, criticism, because yesterday itself the former Chief Justice of India, Mr. Ranjan Gogoi, took oath as a member of Rajya Sabha. There can be different opinions on that particular topic, but the fact is that the post-retirement employment of any of these members of these constitutional bodies and any of such bodies which are presumed to be autonomous in nature, which are presumed to take independent decisions, if they accept any government under the government, if they accept any appointment under the government after their retirement, there is a presumption that the person is or was biased. So this thing should be avoided. So these are certain flaws as far as the Election Commission of India and their rules are concerned. Let us see now the powers and functions of the Election Commission of India. The powers and functions of the Election Commission of India. The first power of Election Commission of India is to prepare the electoral rolls. So all the electoral photo identity cards or EPICs that we have are prepared by the Election Commission of India. Similarly, it determines the electoral constituencies. It determines the electoral constituencies, but that it cannot do so without the help of the Delimitation Commission. So there is a Delimitation Commission of India, which is a temporary body which is constituted time to time to determine the changes in the territorial constituencies of legislative assemblies and in that of Lok Sabha, and based on that particular delimitation, the electoral constituencies are determined by the Election Commission of India, and based on that data, the electoral rolls are prepared. Similarly, the nomination papers are scrutinized by the Election Commission of India. So all the work that is related to the conduct and maintenance of elections is done by the Election Commission of India. It also grants recognition. It also grants recognition to political parties. It also grants recognition to political parties. It also grants symbols to political parties. So this is a very important point. Now there is a particular criteria that has been mentioned which has to be fulfilled by various you can say parties so as to be eligible to become national or state parties. Now let us see what that criteria is, which is very important from your exam point of view as well. So how are the political parties actually recognized? Let us see. We say that Indian National Congress is a national party. We say that Shiromani Akali Dal is a state party. How do we say that? What is the criteria under which a party is declared a national party or a state party? So let us see how a national party is declared. So parties are allotted this particular designation on the basis of their performance in the votes. So let us see how this criteria works out. Number one, to become a national party, a political party has to get 6% votes in 4 or more states in Lok Sabha or Legislative Assembly elections. So a party has to get 6% of the total valid votes polled. In Lok Sabha or Legislative Assembly elections. 6% of total valid votes polled in Legislative Assembly or Lok Sabha elections in 4 or more states. That is how it will be determined that that party has a very widespread presence. Otherwise, if 6% votes are garnered only in one state, then that party will only become a state party. But if 6% of the total valid votes polled have been polled in 4 or more states, that means the party has a widespread presence, and that is how it can be eligible to be granted the status of a national party, plus 4 Lok Sabha seats. So both these criteria have to be fulfilled, only then a party can become a national party. So all this criteria that we are discussing is on the basis of poll performance. How a party performs in elections is the sole criteria on the basis of which a party is declared a state party or a national party. The second criteria to become a national party is, it is an or. So either the first criteria is fulfilled or the second criteria is fulfilled. That if a party wins 2% of Lok Sabha seats. Now we know that the total seats in Lok Sabha are 550. That means we have to find out 2% of 550, which turns out to be 11. That means 11 seats have to be won by a particular political party from at least 3 states. From 3 states. So collectively, if a party wins 11 seats in the Lok Sabha elections from at least 3 states, only then it can get the status of a national party. Now this breakup can be in any way. It can be 1-1-9, it can be 4-4-3. Ultimately, from 3 states, combined seats have to be at least 11, and it has to be from 3 states. Say a party wins all the 11 seats from one single state, then it will not be granted the tag of a national party. So, its spread has to be very wide. The third criteria to become a national party, now there again is an or. So, it can be either of the three criteria if a party wants to be declared as a national party. If it is declared a state party, if it is declared a state party in 4 or more states, then it also becomes a national party. A state party in 4 or more states, then it becomes a national party, right? These provisions are mentioned not under the constitution but under a separate law passed by the parliament. I suppose these provisions are mentioned under the Representation of People Act or the Registration of Political Parties Act. I don't know, I am not able to recall the exact name of the law, but for sure these provisions are not mentioned under the Constitution of India. These were left to the parliament to determine. So, if any of these three criteria is met by a party, only then it can be declared a political party. If one seat each is declared from 11 states, yes, then again, then also it can be declared as a national party, because from at least 3 states it is. So, 11 seats have to be won from at least 3 states. So, if a party gets 1 seat each from 11 states, even then it can be declared a national party, because it has won 11 seats from at least 3 states. So, then it also becomes eligible to be granted a national party status. The first point is that if a party has got 6% of the total valid votes polled in either the Lok Sabha elections or the Legislative Assembly elections of a state in 4 or more states. Say the Lok Sabha elections are held and the voting is held in all the 28 states. If a party gets 6% or more votes in 4 or more states, plus it also gets 4 Lok Sabha seats, only then it will be granted the status of a national party. Say if a party gets 6% of votes but it does not get 4 Lok Sabha seats, then it will not get the status of a national party. Right? Now let us see what is the criteria to be granted the status of a state party. Let us see the criteria to be granted the status of a state party. Now there can be 2 scenarios. One scenario can be the Legislative Assembly elections. Other scenario can be the legislative or the Lok Sabha election, sorry. So in Legislative Assembly elections, there can be 2 criteria. The first criteria can be if the party gets 6% of the votes plus 2 seats. If the party gets 6% of the total valid votes polled plus 2 Legislative Assembly seats, it can be granted the status of a state party. The second criteria is if the party is able to get 3% of the seats in that particular Legislative Assembly or 3 seats, whichever is more. Whichever is more, then also that party can be granted the status of a state party. It could be under the Election Symbols Reservation and Allotment Order 1968. It could well be. I am not able to recall the exact name of the law, but it is under a parliamentary law, that is for sure, and it is not under the Constitution of India. This is what you need to remember. So this criteria is not given in the Constitution of India, it is under some other law. It could well be the law that you are saying. So if either of the criteria is met, let us take an example of this particular provision. If 3% of the seats or 3 seats are won, whichever is more. Say there is a Legislative Assembly. Let us take the example of Uttar Pradesh. In Uttar Pradesh, the Legislative Assembly has around 400 seats. So if we take 3% of 400, it turns out to be 12. That means 3% of the total seats in Uttar Pradesh are 12. So 3% seats is 12 or 3 seats, so whichever is more. That means if you want to get the status of a state party in the state of Uttar Pradesh, then you need to have at least 12 seats in the Legislative Assembly of Uttar Pradesh, because 12 is more than 3. Now let us take another example. Let us take the example of any state assembly that has 60 seats. So any state assembly that has 60 seats, the 3% of 60 is approximately 2. That means any party that gets 2 seats or 3 seats, whichever is more. So here the 3 is more. That means a party that wants to have a status of a state party in this particular state needs to have at least 3 seats in the Legislative Assembly of that state. This is the first criteria. So either this criteria has to be met or this criteria has to be met if a party wants to be declared a state party. After that, in the second scenario, that is the Lok Sabha elections. Now if a party wants to get declared as a state party under the Lok Sabha elections, what it has to do is it has to get 6% of the total valid votes polled plus 1 Lok Sabha seat. Plus 1 Lok Sabha seat, because it is a very vast area, it is a larger area as compared to Legislative Assembly. Therefore, here the number of votes in the state remains the same, but in case of Legislative Assembly elections, a party has to win at least 2 seats, whereas in case of Lok Sabha elections, even if a party wins 1 seat, that would be considered as a fit criteria to be granted as a state party status. The other criteria could be if the party wins 1 Lok Sabha seat for every 25 seats in the state. If the party wins 1 Lok Sabha seat for every 25 Lok Sabha seats in the state. Now to answer your question, say there were elections in the year 2010 and the party fulfills this particular criteria, it will be granted the status of a national party or a state party. Again, elections are held in 2015. If the party is not able to fulfill the criteria, its status will go. So this status is reviewed after every elections. So if a party is able to score any of this point, only then it will maintain its status of a national or state party. But if its poll performance has deteriorated over time, then it will lose this particular status. So this status is reviewed after every election by the Election Commission of India. That is why we are discussing it under the Election Commission of India. So these criteria are reviewed after every Legislative Assembly election in the state and after every Lok Sabha elections in the entire India. So if any party is found not to fulfill this criteria, its status is taken back, and if a new party fulfills that criteria, then that status is granted to that party. So there is periodic review of this situation. Now to be declared a state party, a party has to fulfill any of these 4 criteria. So any one of these 4 criteria, if a party fulfills, that party can be granted the status of a state party. I hope you have understood whatever I have discussed here. If you have any doubt, you can ask me. This is something you need to remember because they ask you this thing in the exams. They can simply ask you which among the following is a criteria to be granted the status of a national party or a state party, or which of the following is not a criteria to be granted the status. So you need to memorize this particular thing. The next function of the Election Commission of India is, very importantly, the code of conduct. Now what is a code of conduct? Code of conduct simply means, yes, the last criteria was that if after the Lok Sabha elections a party wins 1 seat for every 25 Lok Sabha seats in the state, then also that party will be granted the status of a state party. Say in a particular state there are 50 Lok Sabha seats. So if that party wins 2 Lok Sabha seats, because there is 1 seat for every 25 Lok Sabha seats in the state. So if that particular party wins 2 Lok Sabha seats in that particular election in that state, that party will be granted the status of a state party. In national party, the last point of the national party you are asking. So if a party is declared a state party in 4 or more states, then it automatically becomes a national party. Say there is a party that has that is so well represented, that has its presence in at least 4 states, then it will be granted the status of a national party. Then it does not need to fulfill the status of a national party separately. It is a state party in 4 elections, it automatically becomes a national party. Yes, the same criteria. For Supreme Court judge also, while removing the Supreme Court judge, there is a 3-member committee constituted for investigation. The same is done for Election Commission of India as Election Commissioner of India as well. Definitely. If I had skipped that point is still there. So what is a code of conduct? It is a conduct for the political parties to follow. And this is always in news whenever there are elections. So all the politicians and all of those who are campaigning for the elections, they have to follow a certain code of conduct which is enforced by the Election Commission of India. Now another point which is very important is the Election Commission of India advises the President on the disqualification of MPs. On the disqualification of members of Parliament. Now there can be certain grounds on which members of Parliament can be disqualified, and on those particular grounds the Election Commission of India advises the President on whether to disqualify or not to disqualify those MPs. Now disqualification of MPs can be of 2 ways. One is the usual disqualification, the second is disqualification because of defection. When that disqualification is for any other method or for any other reason, then it is governed by the Election Commission of India plus the President of India. But when that particular defection is when that particular disqualification is because of defection, then it is governed by the Speaker or the presiding officer of that particular house. This is very important. Disqualification can be from 2 broad reasons. One is because of defection. If an MP or MLA has defected to his particular party, like they have been elected on a particular ticket but they have switched their party, in that case the presiding officer of that house has the authority to declare defection. Whereas in any other case of disqualification, say there is a criminal case whose verdict has come against a particular MP or MLA, where the punishment is 2 years or more. In that case, the Election Commission of India will advise the President to disqualify that particular MP or MLA. So in all other cases, Election Commission of India is the authority. Whereas in case of disqualification due to defection, the Speaker or presiding officer is the authority. Then the Election Commission of India is also empowered to cancel the polls in case there is any irregularity in the conduct of elections. This is also the Election Commission of India is empowered to do. So in the last Lok Sabha elections, there was one particular constituency where the polling was cancelled because a lot of cash was found in that particular constituency, and that is why the elections were cancelled by the Election Commission of India. Try to find out which constituency it was. Is the President bound to accept the advice of ECI for disqualification? No, the President is not bound to. It is just an advice. So these were the powers and functions of the Election Commission of India, and this was the composition and the status of Election Commission of India. The next constitutional body that we are going to discuss is the Union Public Service Commission. So the Union Public Service Commission is the next body. Now this body is mentioned under Part 14 of the Constitution, and Part 14 deals with services under the Union and states. So Part 14, Articles 315 to 323. They contain the provision for the Union Public Service Commissions, and Union Public Service Commission is also known as the watchdog of merit system in India. The watchdog of merit system in India, because it is responsible for selecting the highest level of officers and bureaucrats for the government of India as well as of the states. It is also an independent constitutional body, and it is the central recruiting agency of the government of India. Let us see the composition of Union Public Service Commission. So it has the chairman and such other number of members as decided by the President of India. So it has one chairman and as other members as the President decides to have. Usually it has around 8 to 12 members. It has anywhere between 8 to 12 members along with a chairman. As far as qualifications of the chairman and members of UPSC is concerned, it has been prescribed that at least one half of the members of the commission should be such persons who have held for at least 10 years any office under the government of India or the state government. That means at least half of the members should be such who have held office under the center or the state government. This particular provision is provided to them. As far as their tenure is concerned, they can serve for 6 years or up to the age of 65 years, whichever is earlier. So say a Union Public Service Commission member is appointed when he is 55 years of age. So he completes 6 years at the age of 61 years, then he gets retired. So his term or 65 years of age, whichever is earlier. No, Election Commission of India does not determine the territorial area of constituencies. It is the Delimitation Commission that does that. Delimitation Commission delimits the constituencies and then it informs the Election Commission of India, and Election Commission of India accordingly makes the electoral photo identity cards of the people who are living in that area. Because every time the Delimitation Commission redraws the boundaries, there is a change in the constituencies of many people. So their new photo identity cards have to be issued and electoral rolls also have to be maintained. So it is done by the Delimitation Commission of India, which again is appointed by the Parliament of India. Then there are various grounds for removal of UPSC chairman and members. There are various grounds on which the UPSC members and chairman can be removed. The first ground is if they become insolvent. So if they become insolvent, that is one ground. Then if they engage in paid employment, they cannot engage in paid employment anywhere in any capacity. If they do, they become disqualified to remain members or chairperson of UPSC. Then if they become infirm in mind or body. So, if there is infirmity in mind or body of any of those members or chairperson, then also they become ineligible, and this has to be done in the opinion of the president. So, if in the opinion of the president they have become infirm in mind or body, but if this particular ground has to be enforced to remove them, then there is a criteria for that, which is known as misbehavior. So, on any of these grounds, if a person has to be removed, then the president has to refer that particular matter to the Supreme Court of India for an inquiry, and whatever advice the Supreme Court will tender is then binding on the President of India. So, if a UPSC member has to be removed on this ground, then the president has to refer inquiry to the Supreme Court of India, and whatever advice the Supreme Court tenders to the president, it is binding on the president. This is important. Whatever advice the president tenders, the Supreme Court tenders to the president is binding on the president in this particular regard. So, it is not like the advisory jurisdiction under Article 143 of the Constitution, where the president can seek advice of the Supreme Court of India on any matter, and the Supreme Court may reply something and the president may or may not accept it. In this particular case, whatever advice the Supreme Court tenders to the president is binding on the president. So, if the Supreme Court says that no misbehavior was done by the election commissioner, then the president cannot remove him. But if the Supreme Court says that there is misbehavior, then the president has to compulsorily remove him. So, any opinion tendered by the Supreme Court in this particular regard is binding on the President of India. This is an important point. Now, Union Public Service Commission is such a body which is prone to various types of you can say influences. So, to make it an independent body, there are various measures that have been undertaken, or there are various provisions that have been provided. First is, the Union Public Service Commission members have a security of tenure. As we discussed, 6 years of age or up to 65, 6 years of tenure or up to 65 years of age, whichever is earlier. Secondly, their conditions of service cannot be varied to their disadvantage. Their conditions of service have to remain constant and they cannot be varied to their disadvantage in any case. Then the expenses and salaries of the members and chairpersons have to be charged on the Consolidated Fund of India. Charged on the Consolidated Fund of India, and by charged on we mean that it cannot be voted in Parliament. When we say that an expenditure is charged on the Consolidated Fund of India, we mean that it cannot be voted in the Parliament, it has to be mandatorily taken. There is no such particular difference between term and tenure, it is one and the same thing. So, the term can be 6 years or the tenure is of 6 years, there is no much difference, it is just a difference of nomenclature. Then, very importantly, the chairman of UPSC is not eligible for further appointment. That means the chairman of UPSC can enjoy only one term as chairman and he cannot be re-employed. So, he cannot be employed anywhere else, whereas the chairman as well as members, the chairman as well as members are not eligible for reappointment. That means they can become the members only once. They cannot have a second tenure at the Union Public Service Commission. That is a very important point with which the independence of this particular body can be maintained. Now let us see the functions of this particular commission. So as we know, the Union Public Service Commission conducts examinations. So it conducts exams, usually for Group A and Group B posts, right? Then it also can do joint recruitment for states as well. It can do joint recruitment for states. Say there is a state which is not able to undertake examinations due to some reason or the other, or the State Public Service Commission is not in a position to conduct the examinations, then the Union Public Service Commission on the behalf of that state can conduct those examinations, but only on the recommendation of that particular state, only on the request of that particular state. So if a state requests something, yes, the salaries of constitutional bodies, the salary of everyone that we have discussed till now, they can be varied in case of financial emergency. Yes, even the salaries of president, vice president, ministers, MPs, Supreme Court, High Court judges, their salaries can be restricted. They can also be cancelled during the financial emergency only. Of course, that is a drastic step which can be taken. Then it can serve the needs of states. It can serve the needs of states as far as recruitment is concerned, but there are two conditions for that. It can be done only on the governor's request. If the governor of that particular state sends a request and if the president approves, So once these two conditions are fulfilled, only then the Union Public Service Commission can conduct the examinations on behalf of that particular state. It is also a consultative body. Union Public Service Commission is consulted whenever any rule for recruitment to civil services or method of recruitment to civil services is to be framed. So it is considered as an expert body as far as recruitment of civil service is concerned. So if any change has to be effected in the method of recruitment of civil services, then the Union Public Service Commission has to be consulted. Then any principle is to be followed in appointment. Now principles to be followed in appointment means that whether seniority principle has to be taken up or merit principle has to be taken up, or it has to be a combination of both, that is not decided by UPSC, but that is decided by government in consultation with UPSC, right? Then any type of disciplinary matters, if a disciplinary action has to be taken against any civil servant, then also the advice of Union Public Service Commission can be sought. This is another important function of the Union Public Service Commission. All these steps have been taken to make it a effective, strong body, and also because it is a autonomous constitutional body. The jurisdiction of UPSC, that what the UPSC can and cannot do, if it has to be expanded, it has to be done by passing an act of parliament. So say the government of India wants the UPSC to conduct some new types of examinations. It wants the UPSC to do some new type of task. Then the Parliament will have to pass an act to empower the UPSC to do that. So after all discussing all these powers and functions of UPSC, now let us see some of the limitations on UPSC or some of the restrictions on UPSC. There are certain things that UPSC cannot do. The first thing is that the UPSC cannot do anything as far as making reservations for other backward classes is concerned. So the UPSC can enforce the reservation only for scheduled caste and scheduled tribes, but not for the other backward classes. It cannot consider claims it cannot consider claims of SCs and STs to services, because that is the mandate of the government and not of the Union Public Service Commission. So, it cannot consider claims of SCs and STs to services and in making appointments. Yes, such a law of parliament has to be passed by simple majority only. It does not require special majority. It is an ordinary law, and if it is for expanding the scope of UPSC, then it has to be passed by simple majority, because expanding the scope is easier than limiting the scope of a constitutional body. But if the UPSC's power has to be limited, then a constitutional amendment is required, and then it would require a special majority. So, for expanding the scope, a simple majority would be sufficient. Then the Union Public Service Commission, there is a limitation of the Union Public Service Commission that it does not select various chairpersons and members of various types of boards and commissions and various other types of bodies, and it also cannot select officers for Group C and Group D services. So, it is concerned mostly with Group A and Group B services. So, it is a sort of limitation. Now, limitation should not always be seen in context of a negative connotation. Limitation means that its functions are limited in a particular sense, which is in a way good also. So, for Group C and Group D services, there are various other agencies which are carrying out that task. So, UPSC is concerned only with the recruitment of Group A and Group B officers, and there are various other chairmans and members of various other tribunals and very high diplomatic nature of appointments. They are not consulted with the Union Public Service Commission. So, that cannot be termed as a disadvantage. That is just a simple limitation on the powers of the Union Public Service Commission. After Union Public Service Commission, we have State Public Service Commissions. So, every state has a State Public Service Commission, and most of the points that we have discussed, that means the Chief Minister of that particular state could have pressurized the members and chairperson of the State Public Service Commission to act in a particular manner. That is why the removal process has been granted to the President of India, which cannot be influenced. Right? All the functions that are performed by UPSC are also performed by State Public Service Commission at the state level. So, all the highest level of state employments, the exam for their recruitment is to be conducted by the State Public Service Commission. Also, the State Public Service Commission is consulted by the governor for framing various rules as far as recruitment and methods of service of Group A and Group B officers are concerned. Similarly, it is also consulted by governor for determining the judicial officers' services in the state, because below the High Court of a state there are subordinate judicial services. Subordinate judicial services include all the judicial services that are up to the rank of a district judge. So, for the recruitment of candidates to the subordinate judicial services, the State Public Service Commission conducts the examinations. So, in this particular regard, if any rule has to be made or if any change has to be effected, the governor of a state has to consult the State Public Service Commission in this regard. And also in this regard, the State High Court is also consulted. So, say the Punjab Civil Services judicial examination is to be conducted. So, the Punjab Civil Services judicial examination will be conducted by the State Public Service Commission of Punjab in consultation with the State High Court as well. So, this is the particular provision mentioned under the Constitution of India. After State Public Service Commission, in some cases there is a provision also for a Joint Public Service Commission. There is also a provision for the Joint State Public Service Commission. Now, one thing you should remember is that the provision for Union Public Service Commission and State Public Service Commission are mentioned in the Constitution. So, they are constitutional bodies, but the provision for a Joint State Public Service Commission is not mentioned in the Constitution. So, it is a statutory body. So, it is a non-constitutional body, but we are discussing it today because it is in conjunction with the State Public Service Commission and Union Public Service Commission. So, it is a statutory body and it is a non-constitutional body. Then how is it created? It is created by an Act of Parliament. Say if 2 or more states have to conduct joint recruitment examinations, for that particular purpose the Joint State Public Service Commission can be constituted. It is done on the request of the states, on the request of the states. Say if 2 states request to the Union government that kindly constitute a Joint Public Service Commission for recruitment to our states, then the Union government or the Parliament can do that. Now, in case of a Joint Public Service Commission, the chairman as well as the members are appointed by the President of India, because no state governor can claim primacy over that particular Joint Public Service Commission. So, President is the one who appoints as well as removes those members. So, President has the authority. Now, in this particular case, the tenure of the members is 6 years or up to 62 years of age. In this particular case also, the tenure of the members is either 6 years or up to 62 years of age. Right? So, there can be 2 situations when a state is not able to conduct examinations or when a state is not able to have any of such agency. So, it can either request the Parliament to form a Joint Public Service Commission with any other state, in partnership with any other state, or it can simply request the Union Public Service Commission to conduct exams on its behalf. Both the options are available to the particular state. Also, one important point, in case of Union Public Service Commission, the annual report of Union Public Service Commission is submitted to the President of India. In case of a State Public Service Commission, the annual report is presented to the governor of that particular state. But in case of a Joint State Public Service Commission, the report is presented to the respective governors. So, say there is a Joint Public Service Commission for the state of Madhya Pradesh and Chhattisgarh. The report of that Joint State Public Service Commission will be presented to the governors of both Madhya Pradesh as well as Chhattisgarh for the respective recruitments that have been made for those states, and not to the President of India. They then, for example, the UPSC submits report to the President then places it before the Parliament. Similarly, the State Public Service Commission submits report to the governor of the state, and the governor submits that report to the particular state legislative assembly. So, you should keep in mind that UPSC and State Public Service Commission are constitutional bodies, whereas Joint Public Service Commission is not a constitutional body, it is a statutory body. So, it is a temporary body anyway, which is formed by passing an Act of Parliament. Another important constitutional body that we have is the Finance Commission of India. The Finance Commission of India's provision is mentioned under Article 280 of the Constitution, and it is a quasi-judicial body. It is a quasi-judicial body. That means it takes certain decisions where it acts as enjoys certain powers of a civil court as well. First of all, let us see the composition of the Finance Commission. So who all are the members of Finance Commission? It has one chairman and 4 other members. Currently the 15th Finance Commission is in operation. The 15th Finance Commission is in operation. Can you tell me the name of the chairperson of the 15th Finance Commission in the comment section? Quasi means not fully, quasi means somewhat. Means it's not a fully judicial body, it is a semi-judicial body, you can say. Semi-judicial body. That is what quasi means. So can you tell me the name of? Yes, the chairman of the 15th Finance Commission is Mr. N.K. Singh. He has recently submitted his recommendations to the Government of India. Yes, N.K. Singh, rightly said. So this is the composition of this particular Finance Commission. Now let us see who all are qualified to become the chairman and members of the Finance Commission of India. So as far as the qualifications are concerned, there are stringent qualifications in place. To become a chairman, a person should have experience in public affairs. So very simply, a person should have experience in public affairs. Now this is a very broad term. So a very open hand has been given to the Government of India to appoint any person as the chairperson of Finance Commission. But if we see the background, or if we see the precedent, most of the people who have been appointed chairpersons of the Finance Commission have been economists of utmost brilliance. People like C. Rangarajan, people like Mr. N.K. Singh have been appointed as chairpersons of Finance Commission, and they have done the job brilliantly. Then as far as the members are concerned, all the 4 members have their specified qualifications. So to become the first member of the Finance Commission of India, the first member has to be either a judge of a high court, or should be qualified to become one. He should either be a judge of high court, or he should be qualified to become a judge of a high court. Now we know that to become a judge of a high court, there is a particular criteria that we had discussed the other day. So that criteria is that either a person has to have held the office of a judicial officer for 10 years, or he should have practiced as an advocate for 10 years in a court. So a person should either be a judge or qualified to be a judge. For the second member, he should have special knowledge of finance and accounts. Special knowledge of finance and accounts. This is the criteria for the second member. As far as the criteria for third member is concerned, he should have experience in financial matters and administration. He should have experience in financial matters and in administration. To become the fourth member of the Finance Commission of India, a person should have special knowledge in the field of economics. So special knowledge in the field of economics. So these 4 members along with this chairperson constitute the Finance Commission of India. Now very importantly, let us see what are the functions of Finance Commission of India. Let us see the functions of the Finance Commission of India. So why Finance Commission of India is constituted? The reason for that is that the center government has more share of revenue as compared to the state government. So the center gets more avenues to earn revenue than the state government does. So a particular pool of the central government revenues has to be shared with the state government, but there has to be a criteria for that, and to determine that particular criteria, a Finance Commission is constituted after every 5 years. And once the Finance Commission submits its recommendations, that recommendation, if accepted by the government, is applicable for 5 years. Like we just discussed, that the 15th Finance Commission has submitted its recommendations, which are yet to be made properly public. So if these recommendations are accepted, they will be applicable from 1st of April 2020 to 31st of March 2025. So for these 5 years, this particular recommendation will be applicable. Similarly, when the 14th Finance Commission submitted their recommendations, it was applied from 1st of April 2015 to 31st of March 2020, which is still in operation. And according to this particular 14th Finance Commission, the center should give 42% of its net tax revenue to the states. So 42% was the devolution which was suggested by the 14th Finance Commission. So what is the function of the Finance Commission of India? First of all, vertical devolution. Vertical devolution means how much money the center will give to states. So in total, what is the percentage or what is the sum that the center should give to the states? Similarly, horizontal allocation. Horizontal allocation means among the states. So say the Finance Commission first of all tells that 42% of your total proceeds have to be given to the states, and if the center government earns 1 lakh crore rupees of total revenue, so 42,000 crore rupees have to be given to the states. But out of those 42,000 crore rupees, how much has to be given to which state and what shall be the criteria for that is also decided by the Finance Commission of India, because it cannot be the case that all the states have to be given equal sum of money, because the population of states is different, their area is different, their needs are different. So all those things have to be kept in mind. Just to give you an example, the states of Uttar Pradesh and the state of Manipur, they cannot be granted the same level of devolution, because Uttar Pradesh is the most populous state of India, whereas Manipur has a very less number of population as compared to this. So it cannot be the case that they are also given 500 crore rupees and they shall also be given 500 crore rupees. So there has to be a criteria that say population is one of the criterias. Then their geographical difficulty or terrain can also be a criteria. Their forest cover can also be a criteria. Their performance in implementing the centrally sponsored schemes can also be a criteria. So all those criteria are decided by the Finance Commission of India. So there are two types of devolution: vertical, how much the center will totally give to states, and then horizontal, that out of that total sum, how much is to be given to which state is also decided by the Finance Commission of India. Other than that, there are also certain grants in aids. So the principles that will govern these grants in aids. There are other grants in aid as well. Other than these devolutions, the central government give grants to the states. So on what grounds those grants are to be paid? Yes, its recommendations are advisory in nature, they are not binding on the government. We will discuss this also. They are advisory in nature, they are not binding, but since it is a constitutional body, if its recommendations are not accepted, the government has to give a reply in the parliament, and that is where the government is at a, that is where the government has to justify that particular provision. Usually till now no government has declined any of the recommendations of the Finance Commission, they have generally been accepted, but in theory, in law, the central government can refuse to implement the recommendations of the Finance Commission, and they are not binding at all. The Finance Commission of India, very importantly, can also recommend to the state governments that what they can do to supplement the resources for panchayats and municipalities. Now this is very important. See, we are discussing Finance Commission of India. So this will decide the devolution between center and states. Then there is also the Finance Commission of State or the State Finance Commission, which determines the devolution between the state and the local government institutions. Yes, they are also appointed by the president. Of course, it is a constitutional body, so the Finance Commission is also appointed by the president. They are appointed by the president. So the State Finance Commission recommends devolution from state to the urban local bodies and to the Panchayati Raj institutions. But very importantly, there are certain grants which are given by the central government to the state government to be deployed in panchayats and municipalities. So for those particular things, the Finance Commission of India can also recommend to the states how to there is one another important point that I want to tell you, that is that they are appointed by the president and all the chairperson and members are eligible for reappointment. So they can be reappointed any number of times. Say there is a member of the 15th Finance Commission of India, the same member can also be appointed as a member of the 16th Finance Commission of India or as the chairperson of 16th Finance Commission of India. So they are eligible for reappointment as well. Right? So this is the Finance Commission of India. What is very important is that this particular topic is extremely important from the current affairs perspective. This is just the static part that we have done. From the current affairs perspective, this is very important. So in a few days, its report will be out and will be published by the government, whether the government accepts it or not, because this is the month of March, and in a few days, this particular provision has to be accepted. Are you experiencing any technical difficulty? There seems to be a technical glitch. Am I audible? Am I visible? Please comment in the comment section if I am audible as well as visible. Okay. So this was the Finance Commission of India. So I was saying that since this is the month of March and the next Finance Commission recommendations have to be implemented from 1st of April 2020, that means in a few days you will get a news whether the government accepts the recommendations of the 15th Finance Commission or not. There will also be changes with regard to the position of Jammu and Kashmir. Since those 42% were recommended for all the states combined, but now Jammu and Kashmir is no longer a part of that particular equation. So for UTs, the Finance Commission does not recommend any devolution because they are already under the central government. This devolution is only for the states. So since now Jammu and Kashmir is no longer a state, the Finance Commission might reduce the allocation to the states, but no one can say. It has to be seen what percentage do they recommend for the devolution to the states, and also if there is any change in criteria. And this criteria we are not discussing because every Finance Commission changes the criteria. But just like I told you, the criteria is generally like population is one of the criterias. So say any state that has high population will receive higher funds and that has low population will receive lower funds. Similarly, the geography or the terrain of that state is also one of the criteria. Now that is the reason why most of the hilly states, they receive higher allocation as compared to those states which are in the plain areas. Similarly, the border states, they also receive a bit more in funding as compared to those that are not bordering states. Then the forest cover, if any state has shown improvement in their forest cover, then that also is a ground for a few 100 crore rupees here and there. But again, all this criteria is the discretion of the Finance Commission of India. Now, what will be important for you is who is the chairman and members of the 15th Finance Commission, what are the recommendations of the 15th Finance Commission, and what is the criteria that has been devised by the new Finance Commission to grant the particular funds. Of course, the percentage of devolution is very important. Now, the next body that we are discussing is the National Commission for Scheduled Castes. The next constitutional body that we are discussing is the National Commission for Scheduled Castes. Or NCSC. Let us see a brief background of this particular body. So, earlier this body was under article that they should get separate representation. So, with 65th Constitutional Amendment, 65th Constitutional Amendment Act, a new article, Article 333A was added. Article 333A was added. Basically, this body was taking care of the concerns of scheduled castes, scheduled tribes as well as OBCs. So, after 65th Constitutional Amendment, this new article was added which made a new body called the National Commission for Scheduled Tribes. So, a new body for scheduled tribes was constituted. Recently, by 102nd Constitutional Amendment Act, a new body under Article 338B called the National Commission for Backward Classes was also constituted. That means earlier there was one single body for all the three types of communities to look after their interests. Now we have National Commission for Scheduled Caste under Article 338, National Commission for Scheduled Tribes under 338A, and National Commission for Backward Classes under 338B. So now we have three separate bodies for three separate commissions. Pardon me, this is not 65th Amendment, this is 89th Amendment. So let us first discuss the National Commission for Scheduled Castes. The National Commission for Scheduled Castes, let us discuss the composition first. So who all are there in the National Commission for Scheduled Castes? There shall be a chairperson, then there shall be a vice chairperson, then there shall be 3 members. So it is a 5-member body. The National Commission for Scheduled Caste is a 5-member body. All the members are appointed by the President of India, since it is a constitutional body, and in most of the constitutional bodies the President appoints the members as well as the chairpersons. Their conditions of service is also determined by the President, and their tenure of service is 3 years. So they serve in office for 3 years. As far as the functions of this commission are concerned, the functions of this commission are concerned, it can investigate. The purpose of National Commission for Scheduled Caste is that even if the usual machinery of the state is not listening to any of the say the police is not listening to you, the judiciary is not listening to you, and any other authority is not listening to your concerns, then the National Commission of Scheduled Caste is specifically there to safeguard the interests of this particular community. So the first function of this commission is to look into the safeguards, that have been provided either under the Constitution of India or under any other law for the welfare of scheduled castes, and it can also recommend any changes to these provisions as well. For example, the Constitution of India provides for reservation to the scheduled castes, but if any change has to be effected in this particular provision, or if this provision is not properly implemented, then it is for the National Commission of Scheduled Caste to see that what can be done to improve this particular scenario. Secondly, it can inquire into specific complaints. It can inquire into specific complaints of the National Commission. It can inquire into specific complaints that the scheduled castes have made. Then another function is it can advise on the development of the scheduled castes, and it can also evaluate the progress of scheduled castes. So, it can take up the work of evaluation of the progress of scheduled castes. There are various constitutional, legal and other mechanisms for the welfare of scheduled castes, but if any change has to be effected in that particular provisions, then it has to be seen by the National Commission for Scheduled Castes. Another function of National Commission for Scheduled Caste is to make recommendations to the union and state for effective implementation of those safeguards. So, effective implementation of safeguards that are there for the welfare of scheduled castes has also to be ensured. So, there was a technical glitch. Let me know from where did I leave. So, we were discussing the functions of National Commission for Scheduled Castes. I hope it is visible as well as audible now. There was a technical glitch. Let me know in the comment section if now everything is fine, if I am visible as well as if you can hear me. Yes, I will repeat whatever I have discussed in the past 10 minutes. So, simply what we have to see is that originally there was no provision for National Commission for Scheduled Caste and Scheduled Tribes. Originally, the Article 338 of the Constitution provided for special officer for Scheduled Caste and Scheduled Tribes. So, Article 338 provided the provision for special officer for Scheduled Castes and Scheduled Tribes. But with the 65th Amendment to the Constitution of India, a body called the National Commission for Scheduled Caste and Scheduled Tribes was formed. After that, by 89th Amendment, a new body called National Commission for Scheduled Tribes was formed. That means this body was basically split into two, National Commission for Scheduled Caste and National Commission for Scheduled Tribes. And recently, by 102nd Amendment, another body called National Commission for Backward Classes has been formed. So, earlier this single body called the National Commission for Scheduled Caste and Scheduled Tribes was responsible for safeguarding the interest of all the three communities, the Scheduled Caste as well as Scheduled Tribes as well as the backward classes. Later on, a separate body for Scheduled Tribes was made, and recently a separate body for backward classes has also been made. That means now there are three different bodies for Scheduled Caste, for Scheduled Tribes and for backward classes. The body that is there for Scheduled Castes is under Article 338 of the Constitution. The body which is there for Scheduled Tribes is under 338A, and that for BCs is under 338B of the Constitution. So, now there are three separate bodies for all the three communities. Then I was discussing the functions of these bodies. specifically why I was discussing the functions of the National Commission for Scheduled Caste. I also discussed the composition of this commission. So the composition of this commission is it is composed of 5 members. One is the chairperson, then second is the vice chairperson, then there are 3 members. So it is a 5-member body with 1 chairperson, 1 vice chairperson and 3 other members. So a total of 5 members, and they are appointed by the President of India. They are appointed by the President of India. These are the important provisions, and their tenure is 3 years. They serve in office for a 3-year term. After that, let us see what the functions of National Commission for Scheduled Caste is. First of all, it looks into the safeguards that are there in the Constitution of India and in various other laws for the welfare of scheduled castes. So it looks whether the safeguards that have been provided under law are being implemented properly or not. Secondly, it inquires into specific complaints that are made to this particular commission. So whenever there is a discrimination against any scheduled caste, or whenever any provision of the law is not implemented, the scheduled caste person can directly approach the National Commission and register his complaint there. Thirdly, it evaluates the progress of scheduled castes. So it evaluates, I'll tell you about their removal as well later. So it evaluates the progress of scheduled castes, that whatever progress the scheduled castes were expected to make, has that progress been made or not. And it also sees to it that whatever safeguards are provided in the Constitution and in all other laws, they are implemented or not. This also is under the purview of the National Commission for Scheduled Castes. In the end, it submits its annual report. Whatever work it has done, the report has to be submitted to the President of India. So it submits its annual report to the President of India. Now let us see the powers of National Commission for Scheduled Caste. Very importantly, since we discussed that it is a quasi-judicial body, now quasi-judicial means it has certain judicial powers as well. In those judicial powers, the first power is it has the powers of a civil court. Now what are the powers of a civil court? Civil court has powers that it can issue summons to anyone to enforce their attendance. It can force anyone to produce any document or evidence before the court. It can enforce the attendance of any person before itself. Then it can follow the procedure of that is mentioned under the law. So it has the power of investigation, and while investigating it has all the powers of a civil court. Let us see some of those powers. The first power is summoning and enforcing the attendance of a person. Summoning and enforcing the attendance of a person. So since it is a court can issue summons and it can enforce any person to appear before the particular court. Similarly, it can ask for the evidence or document from anyone, and then it has to be mandatorily provided to the commission, because otherwise the person is liable for punishment. Similarly, it can ask for or requisition any public record. It can requisition any public record in any public or any public document from any government or semi-government organization, and it can also issue summons. So all these are the powers of a civil court which are exercised by the National Commission for Scheduled Castes. That means whenever it is investigating into any specific case, it acquires some of the powers of a civil court, under which all these provisions are available. Then the governments, center as well as state governments are required to consult the National Commission for Scheduled Castes whenever they are making any policy on scheduled castes. Say a particular state or the center government is going to make any provision for the welfare of scheduled castes, or it is going to change any provision which is already there which concerns the scheduled castes, then the government has to mandatorily consult the National Commission for Scheduled Castes. However, such a recommendation that the National Commission will grant is not binding on the government, but still the government has to seek the advice of that particular commission. This is the mandate of this commission. As far as National Commission for Scheduled Caste is concerned, it is also required to look into the concerns of the Anglo-Indians. So there is no separate commission for Anglo-Indians as yet. So Anglo-Indians and their concerns are also looked after by the National Commission for Scheduled Castes. As far as their removal is concerned, now importantly, they can be removed by the President at any time. So they do not enjoy any such proper powers as are enjoyed by the election commissioners or by the Supreme Court judges. So they can be removed at any time by the President under his hand and seal. However, whenever such an action has to be taken, the issue is discussed in the Parliament and there the government has to come up with a specific reply. So since it is not a very powerful position, therefore no such stringent checks have been enforced or has been imposed on their removal. So they can be removed by the President. Similarly, there is a National Commission for Scheduled Tribes. National Commission for Scheduled Tribes, which was created by the 89th Constitutional Amendment Act, and Article 338A was added to the Constitution. Now, scheduled tribes by definition are different from scheduled castes, and since they are geographically and culturally different, that is why a separate commission for them was recommended. So all the points that we have discussed in the National Commission for Scheduled Caste are similar in National Commission for Scheduled Tribes as well. It is also a 5-member body having one chairperson and one vice chairperson and 3 members. They are also appointed by the President of India, and all the functions of this particular commission are also analogous to that of the National Commission for Scheduled Castes. However, this commission looks after the welfare of the scheduled tribes specifically. So since geographically and culturally the scheduled tribes are different from scheduled castes and their problems are also different, that is why this commission was carved out. Also, in the year 1999, a separate ministry for tribal affairs came into picture. Separate Ministry of Tribal Affairs came into being. This is another fact that you can remember. Then the National Commission for Backward Classes, the National Commission for Backward Classes is there, and its provision was made by the 102nd Constitutional Amendment Act, and it added Article 338B to the Constitution of India. This amendment was done only last year, and this National Commission was granted constitutional status. Again, the composition and all other provisions for this commission are the same, and it also has one chairperson, one vice chairperson and 3 members. The President will determine their working conditions. The President appoints them. They also submit their report to the President of India, which the President then submits to the Parliament. So all the 3 commissions submit their reports to the President, which are then submitted to the Parliament. Again, whenever this commission is investigating into any complaints against the backward classes, it also has the powers of a civil court, which include the power to summon anyone, the power to enforce the attendance of anyone, the power to produce any evidence or document before itself, and all that. So there are no specific changes as far as these provisions are concerned. Now, next very important constitutional body. So, all these are constitutional bodies. These three national commissions, since they are mentioned in the Constitution under Article 338 and 338A and 338B, so these are constitutional bodies. Another very important constitutional body is the Controller and Auditor General. Which is in short known as CAG. So, the Controller and Auditor General is the next constitutional body that we are going to discuss. It is not a body as such, it is a office. So, can you tell me in the comment section who is the Controller and Auditor General of India at present? Can you tell me who is the Controller and Auditor General of India at present? Yes, Mr. Rajiv Mehrishi rightly said is the CAG of India at present. So, let us see what a CAG is, what are the provisions provided under the Constitution, and this office has been under news for quite some time now. It was in news for the first time when the 2G spectrum scam was, when it was in news. So, most of the yes, very good question you have asked. So, controller, it is pronounced as controller, but this controller here means the controller of accounts. So, controller is a word which means controller of finances or accounts. So, controller, or you can say controller, it is actually pronounced as controller only. So, this is not a spelling mistake, it is actually true, it is known as controller only. So, controller is someone who controls the finances or accounts of a particular body or a particular country or a particular state or a particular body. So, this is not a spelling mistake in the Constitution, this is perfectly fine. It is a word of the Constitution, it is a word of the English actually. So, the provision for controller is provided under Article 148 of the Constitution, under Article 148 of the Constitution. Very importantly, Mr. B.R. Ambedkar had described CAG as the most important constitutional functionary. This is very important. This has been asked various times in various exams, that which constitutional functionary did Dr. B.R. Ambedkar describe as the most important constitutional functionary. So, you may get confused there. The options would be like Prime Minister of India, the President of India, or the Chief Justice of India, and then there will be Controller and Auditor General. There can also be other options like Chief Election Commissioner. So, you might think that all of them are important, but the reason why Dr. B.R. Ambedkar said that CAG is the most important office, the reason for that is that CAG is that authority that keeps a check on the financial improprieties of the government. This is that authority that actually audits the accounts of all the governments. That is why it is considered to be the most important constitutional functionary by Dr. B.R. Ambedkar. So, let us now see the appointment and term conditions of the controller. If he has to resign, he resigns to President of India, which is true in case of all other bodies that we have discussed today as well. So, if a Chief Election Commissioner has to resign, he will also resign to the President. The members and chairpersons of the National Commissions of Scheduled Caste, Scheduled Tribe, if they have to resign, they will also resign to the President. So, since all of them are appointed by the President, they are also answerable and they also resign to the President only. As far as removal of CAG is concerned, now he is such a important functionary, his removal is same as that of a Supreme Court judge on the grounds of proved misbehavior and incapacity. so as to maintain the independence of his office. So, a very stringent and very cumbersome removal procedure is put in place if the CAG has to be removed. As far as independence, maintaining the independence of this particular office is concerned, all the provisions are same. So, he has the security of tenure, he cannot be removed before his term is completed. Very importantly, he is not eligible for further office, not eligible for further office. That means he cannot accept any post-retirement designation or employment under the government of India or under the government of any state. His conditions of work cannot be varied to his disadvantage when for the time being when he is in office, right. Also, no one, including any minister, can represent CAG in the Parliament. So, no one can represent CAG in Parliament. If a CAG has to represent, he will represent himself in the Parliament and no one can do so on his behalf. Also, no minister can be called upon to take any responsibility for any action that has been done by the Controller and Auditor General, and CAG is himself responsible and answerable to the House in that particular case. Let us now see the powers and functions of CAG. So, his most important function is now very importantly, these powers and functions are not mentioned in the Constitution. These powers and functions have been mentioned in a separate law that has been passed by Parliament. So, this law is CAG, Duties, Powers and Conditions of Service Act. So, the name of the act is CAG, Duties, Powers and Conditions of Service Act. So, under this particular law, the powers and functions of CAG have been mentioned. Now, let us see what those functions are. He audits the consolidated fund of India, states and those of UTs with legislative assembly. So, he audits the accounts of number 1, the center government, number 2, the state governments and number 3, UTs with assembly. Because the UTs which are without assembly come directly under the central government only. So, the CAG audits the accounts of central government, state government and those UTs with assembly. Now, in this particular category, we have Delhi, Puducherry and the Union Territory of Jammu and Kashmir. So, he audits the consolidated funds. I should write there consolidated fund. So, audits the consolidated fund of these three. He also audits the contingency funds. So, what is a contingency fund? As I told you, a contingency fund is such a fund from which the Prime Minister or Chief Minister can withdraw any money without taking the consent of the Parliament or the state legislature, as the case may be. And once that money is spent, after that the permission of the House can be sought. So, this is as the name suggests, it is for emergency or contingency. So, in case there is any natural disaster, so in that case there is no time to seek the permission of the House. So, in that case the funds from this particular you can say fund can be withdrawn and after that the Parliament can be asked for the permission. I did not understand your question that you have asked in the chat section. the salaries and allowances of all the constitutional functionaries that we have discussed today, including the Chief Election Commissioner, Election Commissioners, UPSC chairperson and members, the National Commission of Scheduled Caste, scheduled members working under the hundreds, or it could be in thousands as well. So there is a service called the Indian Audit and Account Service. This is also a Group B service under the UPSC to take. In this, there is a service called Indian Audit and Account Service. So all those officers who are selected under Indian Audit and Account Service, they work under the office of CAG only. Yes, yes, of course, there are hundreds of officers under him. This is just an institution which is headed by Mr. Rajiv Maharishi. So hundreds of officers, in fact thousands of officers are there in the union, state as well as UTs, which are actually undertaking the task of auditing all the accounts. Right? So he audits the consolidated fund of all these, he audits the contingency fund of all these, he also audits the public account of all these. Public account is another account which is maintained by the central government and by the state government. Is there a problem in the transmission of video? I have asked for technical support, they will be looking into it. The qualification to become the Controller and Auditor General, no such qualification has been mentioned. Any person who has knowledge in finance or any person who has, there is no specific qualification mentioned. That is one of the flaws of the Controller and Auditor General. No specific qualification has been mentioned for becoming the Controller and Auditor General. But again, I would say, whatever persons have occupied this esteemed office, they have been of utmost integrity, and most of them have been senior IAS or IAAS officers, but no qualification has been mentioned as such. So after the Controller and Auditor General has made his report, he submits these reports. In case of the center, he submits the report to the President of India, and in case of states, the report is submitted to the governor of that particular state. Yes, I have asked for technical support. They are looking into it, that why there is a technical glitch. Okay, so let us discuss the next important function of CAG, which is very important. So the other day we had discussed three types of parliamentary committees. There was a public accounts committee, then there was an estimates committee, and then there was a committee on public undertakings. So we discussed these three parliamentary committees. Out of this we discussed the public accounts committee, which is headed by a member of the opposition, and it has 22 members, 15 from the Lok Sabha and 7 from the Rajya Sabha. The main purpose of this public accounts committee is to scrutinize the report of the CAG, to scrutinize the report that has been submitted by CAG. That is why a member of opposition has been made the head of this particular committee, so that if there is any irregularity that has been caught in the report of CAG, it has to be revealed before the opposition and not before the government. Right? So the CAG is known as the friend, philosopher and guide of the Public Accounts Committee. This is very important. This question has been asked in a previous exam, that who is considered as the friend, philosopher and guide of the Public Accounts Committee. So it is the Controller and Auditor General of India. He has been termed as the same. So this is the last body that we are discussing. If you are asking, this is the last constitutional body that we are discussing. After this, we will in brief see Schedule 5 and Schedule 6. So very briefly, I will tell you about the areas that fall under Schedule 5 and Schedule 6 and some provisions in brief, because this is the last constitutional body that we are discussing. We are already done with all the constitutional bodies. There are Attorney General and Advocate General, which we have already covered under the executive, and then there are Supreme Court and High Court of India, which we have already covered under the state judiciary and union judiciary. This is the last independent constitutional body that we are discussing. So his relation, the relation of CAG with the Public Accounts Committee is very important. In the end, let us see the final function of CAG. So the CAG submits three types of reports. The CAG submits three types of reports to the President in case of central government audit and to the State Governor in case of the state audit. The first report is on the appropriation account. The second report is on the finance account. And the third report is on the public undertakings. Let us see what these three reports are. What is the difference between an appropriation bill and a finance bill, or the difference between an appropriation account and a finance account? No, any of the members can be from, see there are 22 members in the Public Accounts Committee. Out of these 8, 10 or 12 members can be from opposition. Generally the chairperson of this commission is from the opposition, and after that this composition of this commission is based on the proportion of that particular party in the house. Say there are 15 members from Lok Sabha and there are 7 members from Rajya Sabha. Now in Lok Sabha there are 15 members in this committee. So if the BJP is in majority in the house, that means out of these 15, say 8 members will be from BJP. So if the Congress is the second largest party, 2 members will be from Congress and 1 member each will be from different other parties. So the composition is like that, so that the entire Lok Sabha is represented in these 15 people and the entire Rajya Sabha is represented in these 7 people. So all the members are not from opposition, also all the members are not from government either. So it is a mixed composition so that it can represent the parliament in totality. Now let us see the difference between these three. So appropriation and finance, these are the two bills which are passed when the budget is introduced in the house. So the budget is basically composed of appropriation bill and finance bill. Finance bill is that bill that leads to the income of the government. So all those measures of the government through which income is generated by the government, that is the by way of finance, and all the expenditure of the government is mentioned in the appropriation bill. Therefore, it simply means is that the CAG submits first report on the expenditure of the government and second report on the income of the government. Thirdly, on public undertakings. Now public undertakings means all the public sector undertakings like the Life Insurance Corporation of India, the Oil and Natural Gas Corporation. There are hundreds of such public sector undertakings, and on that there is a separate report. So these three reports are presented to the President in case of central government audit and to the state government in case of, to the governor in case of state government audit. So these are the three reports which are submitted by the Controller and Auditor General of India. So his role now, as you can tell, is very important. All the financial scams that we have seen, like the Bofors scam or the 2G spectrum scam, or the coal block allocation scam, or the Commonwealth Games scam, all the scams that we have heard of, most of them have been exposed by the Controller and Auditor General in his reports. That is why it is a very important office in this regard, because it audits each and every, we take each and every transaction that the government mentions, or we take for granted each and every figure that the government mentions in the budget and in the economic survey. But in reality, all of those figures are vetted, they are thoroughly probed by the Controller and Auditor General. That is why, that is how the propriety can be ensured. Now, these are all the constitutional bodies that we have discussed, but after this, since we have some time at hand, I want to discuss Schedule 5 and Schedule 6 in brief. So, we saw, I will just tell you in brief what the provisions under those two schedules are that are important from the point of view of your preliminary examination. So, Schedule 5 talks about the scheduled areas. We will see what all areas fall under this particular schedule and what are the specific provisions for those areas. So, under Schedule 5, there are scheduled areas and scheduled tribes. So, what are the states, what are the names of those states in which this particular provision is there? Can the CAG be reappointed? CAG can be reappointed, but he cannot be further appointed. What it means is that a CAG can be reappointed as a CAG, but once the CAG retires, he cannot be appointed at any other position. That is the situation. So, there are various states in which the President has designated certain areas as scheduled areas, and those states are Himachal Pradesh, Rajasthan, Gujarat. These are the states in which the President has notified various areas as scheduled areas. It also includes Maharashtra, Madhya Pradesh, Maharashtra, Madhya Pradesh, Chhattisgarh, Jharkhand. So, in these states there are areas where the tribal population is a lot, in Odisha and in Andhra as well. So, in all these states, certain particular areas have been declared as scheduled areas. Certain areas have been declared as scheduled areas by whom? By the President of India in consultation with the governor of that state. Say in the state of Jharkhand, there is a particular area where the tribals live in majority. So, for that particular area, the governor would have recommended to the President that kindly declare this area as scheduled area, and after that the President would have notified that area as scheduled area. Now, what is so special about this scheduled area? What is important about this is that there is a Tribes Advisory Council. Tribes Advisory Council in all these states. Now, what does this Tribe Advisory Council do? It has 20 members. It has 20 members. So, each state has this Tribes Advisory Council, each of these states has this Tribes Advisory Council, and there are 20 members in this particular council, out of which 15 have to be the representatives of scheduled tribes in the Legislative Assembly. So, 15 out of this have to be the representatives of scheduled tribes in the Legislative Assembly of that particular state. That means 15 of these are MLAs, so that they can be given representation in that particular state legislative assembly. Right? Then there is another very stringent provision for these areas, that if any law is to be applicable, if any law has to be applied to these particular tribal areas, then the governor will decide whether the law will apply or not. Whether any law is to be applied to these areas, it is decided by the governor. So a governor can say that this particular law that has been passed by the parliament, or this particular law that has been passed by the state legislature, will not apply to this scheduled area, or will apply to this scheduled area with as many modifications as the governor may suggest. So this is very important. Also, if any regulation has to be made for these areas, the governor has to consult the tribes advisory council before implementing that particular decision. All these provisions have been done so as to give a certain autonomy to the tribes that are living in those areas. Right? There is another important provision. So tribes advisory council is the most important part of scheduled tribe of schedule 5. So every state has a tribes advisory council. Each of these states has a tribes advisory council. Now the constitution requires the President of India to appoint a commission to report on the administration of scheduled areas. So the constitution says that the president should appoint a commission to report on the administration of scheduled areas, that commission should say that these areas are being administered properly or not. And in pursuance to that particular provision, the President of India appointed first such commission in the year 1960. So a commission has to be appointed. The constitution mandates that by the President of India, to see whether these areas are being administered properly or not. In the year 1960, this commission was established under UN Dhebar. So UN Dhebar was the first chairperson of this particular commission, and the second such commission was appointed in the year 2002 with the chairmanship of Dilip Singh Bhuria, with the chairmanship of Dilip Singh Bhuria. So this is a constitutional obligation of the president to appoint such a commission. So this is what schedule 5 areas are. So they have tribes advisory council, and any changes can be affected by the governor of that state for implementing any union or state law to the tribes advisory council. If we see schedule 6 areas, now schedule 6 areas talk about the tribal areas. Those were scheduled areas and scheduled tribes. Now we are talking about the tribal areas. Now this is one notch further than schedule 5. So the level of autonomy in schedule 6 is way greater than that of schedule 5. So the tribal areas are in 4 states of Assam, Tripura, Meghalaya and Mizoram. So these are the 4 states in which there are scheduled areas. Is Goods and Services Tax Council a constitutional body?
According to GST Council.
Am I audible? Okay. So yes, you are asking, is Goods and Services Tax Council a constitutional body? Yes, it is a constitutional body, but we will discuss when we will discuss the center state financial relations. So at that time I will tell you in brief about the Goods and Services Tax, that is the 101st constitutional amendment, and in brief I will also tell you about the Goods and Services Tax Council. That is why I have not taken it up along with this topic. So under the Schedule 6, the special provisions have been provided for Assam, Tripura, Meghalaya and Mizoram. Now there are comment in the comment section. The third is the Bodoland Territorial Area District. As far as Tripura is concerned, there is Tripura Tribal Areas District. There is Tripura Tribal Areas District. In the state of Meghalaya, there are 3 districts: Garo Hill District, the Khasi Hill District and Jayantia Hill District. Garo Hill District, Khasi Hill District and Jayantia Hill District. Then at the 4th is the state of Mizoram. If you can hear me, please comment in the comment section. वही प्रॉब्लम है सर फिर से, आई थिंक वो लाइव नहीं है अभी, दोबारा आप ठीक करोगे तो कोई कमेंट नहीं आ रहा है।
कंटिन्यू चलता जा रहा है, बैक एंड उधर तो क्लियर आ रही है।
Okay. So I was telling, okay, so we were discussing Schedule 6. So under Schedule 6 there are provisions for 4 different states: Assam, Tripura, Meghalaya and Mizoram. And under these 4 states, total of 10 areas have been declared as tribal areas. Those areas in the state of Assam are the North Kachar Hill District, the Karbi Anglong District and the Bodoland Territorial Area District. These names are very important. So in Assam, these 3 districts. In Tripura, there is only one, the Tripura Tribal Areas District. In Meghalaya, there is Garo Hill District, Khasi Hill District and Jayantia Hill District, which is easy to remember because these are also the 3 mountain ranges in the state of Meghalaya. Then in Mizoram, there is Chakma District, Mara District and Lai District. So these 10 hill districts or districts have been declared as the Schedule 6 areas by the President of India. These areas have been declared as Schedule 6 areas in the Schedule 6 by the President of India. What is the rationality that why the areas in only these 4 districts have been declared? Because the tribes in other parts of India are closer to the civilized culture, but the tribes in these states still have their roots in their own culture, they have their own customs and civilization. So to give them that level of autonomy, special provisions have been carved out. Now what are the provisions in this particular schedule? First of all, there is a provision for autonomous districts. There is a provision for autonomous districts. Now autonomous district means that in these districts there will be district councils. there will be district councils. Just like under Schedule 5 there are tribes advisory councils, in these particular districts there are district councils in which there will be 30 members. There will be a total of 30 members, and out of these 30 members, 4 members will be nominated by the governor and 26 will be elected. So, 4 members are nominated by the governor and 26 members are elected. Right? Now, these autonomous districts and these district councils are very powerful. Let us see some of the powers that these councils have. What all are the powers that are enjoyed by these district councils? So, first of all, they can make laws. This is a very important power. They can make laws. So, for these particular districts, they have the power to make laws. That means we have virtually given them the power equivalent to that of a legislative assembly of state, but without giving them a separate state. So, they can make laws, however, it can be done only with the assent of the governor. So, they can make laws, but it has to be done with the assent of the governor. That is why the governor directly controls or directly administers the district councils. Also, they have the power to impose certain taxes, again with the consent of the governor of that particular state. A very important provision other is that they can grant license, for the extraction of minerals, and they can also collect royalty for it. They can grant license or lease as well for extraction of minerals, because these states are the hotbed of minerals. So, if there has to be any extraction of minerals or if there has to be any type of mining there, the license or lease for that mining has to be given by these district councils, and any royalty that will be received in that behalf will also go into the pockets of the tribals only. This has been done so that the tribals cannot be exploited, and the royalty is also given to the tribals only. So, this is a very important provision. These provisions have been specifically done so that the tribals do not feel exploited at all. Then, in another significant power, the laws of the parliament as well as the state legislature, they do not apply to these autonomous districts with or without the permission of or with the modifications as prescribed by the governor of the particular state. So, this is very important. Any act of parliament or state legislature, any act of parliament or state legislature do not apply to these autonomous districts without the consent of the governor. That means that is a safeguard which is provided to these particular autonomous districts. Right. So, if you have any doubt you can ask me. This was in brief about the 5th schedule and the 6th schedule as well. There is one more provision I want to tell you about, which is a unique provision in the sense that no such parallel is there in the Constitution of India. So it is a one of its kind provision which is under Article 244A of the Constitution. Under Article 244A of the Constitution, there is a provision for an autonomous state as well. Now you will be surprised to know that there is an autonomous state in India. We have talked about autonomous district, but what is an autonomous state? So this autonomous state has a chief minister. This autonomous state has a chief minister, and it also has a council of ministers, and it also has a legislature. And it is in the state of Assam. Can you tell me the name of this autonomous state? Can you tell me the name of this autonomous state within the state of Assam, which has a legislature and which also has a council of ministers? I do not have any idea until when Abhimanyu classes will be live, but you will get a message on your registered number whenever there is a change. So yes, you are right, Priya. Bodoland Territorial Administration is the right answer. So Bodoland Territorial Administration is the right answer. So there was a huge backlash, there was a huge protests in which the Bodos were demanding a separate state for themselves. So the government of India did not agree to grant them a special state, but they granted them the status of an autonomous state within the state of Assam. So they were granted their own council of ministers, their own small legislature, which can make laws in some specific subjects. They can impose their own taxes. Any other state law or parliamentary law does not apply to them, and they have so many other checks and safeguards. So Bodoland was made an autonomous state. This particular provision was granted. So Schedule 5 and Schedule 6 tells us that no single formula is there in India as far as governing is concerned. There is center, then there are states, then there are UTs, then there are UTs with assemblies, without assemblies. Then we have Schedule 5 areas in which there is a different type of autonomy. Then we have Schedule 6 areas in which we have different types of autonomy. And then there is Article 244A, under which we have a totally different type of unprecedented system, just because we could not give them a proper state because it was not viable according to the government, and also because we had to give them something. So we gave them an autonomous state. So this is a very accommodative stance. This tells you that there is no single model of governance in India. So if you have any question, you can ask me regarding any of the constitutional bodies that we have discussed today, or regarding Schedule 5 and Schedule 6. You don't have any questions? So tomorrow we will be discussing the non-constitutional bodies. If you have any questions, you can ask me. If you didn't understand anything, even from the previous lectures. What about Nagaland? No, Nagaland is not covered either under Schedule 5 or Schedule 6. It has its own provisions. See, the Naga issue is separate. Nagas are demanding the state of Greater Nagalim. So they are also demanding a separate state. Yes, there are so many different governments in Nagaland, but no new mechanism has been carved out for Nagas. There is no constitutional provisions for them as such. There is a separate legislative provision for that. The provisions are not there in the constitution. Also, a new Naga Accord has been signed between the Government of India and the Government of Nagaland, but that accord has not been made public yet. The accord was signed 4 years back in 2015-16, but till date the details of that agreement have not been revealed, so we don't know what that Naga Peace Accord is. No, those governments are perfectly legal. The thing is, they are legal but they are not constitutional. Their provision is not there in the Constitution of India, but that provision is somewhere definitely there in a parliamentary law which is separate. So we are not concerned with that because we are discussing the Constitution of India. Of course, they are legal bodies, but they are not constitutional bodies. So since it is not constitutional, there cannot be a single formula. That law can be amended any number of times and there will not be specific provisions for that. Now, Nagaland does not have its army. There can be a small law and order maintaining machinery, but they do not have their own army. So you want to know that in case of national party, what is the first criteria with examples. So the first criteria for national party was that it has to secure 6% of the total valid votes polled in that election in 4 or more states plus 4 Lok Sabha seats. Let me give you an example. Say the Lok Sabha elections are held in India. Lok Sabha elections are being held in India. So there are 28 states in India as of now. So in these 28 states, in all the states the elections will be held. So say there is a political party which has secured, let us take the example of 4 states. The states are Punjab, Haryana, Himachal Pradesh and Rajasthan. So out of the total votes that have been polled in these 4 states, if that political party secures say 10% votes in this, 12% in this, 14% in this and 16% in this state, that means that political party has been able to secure at least 6% of the total votes that have been polled in these states. If 1 lakh votes were polled in Punjab, this party has got 10,000 votes. And similarly in all other states, whatever total votes were polled in that state, this percentage was polled by this particular party. That means it fulfills the first criteria. So now this party has at least 6% of the total valid votes polled in at least 4 states. Plus, it also needs to have 4 Lok Sabha seats. Now, it is not necessary that these 4 Lok Sabha seats will have to be from these states. They can be from any other state as well. Say the same party has one Lok Sabha seat in Tamil Nadu, 1 Lok Sabha seat in Karnataka and say 2 Lok Sabha seats in Andhra Pradesh. So it has a total of 4 Lok Sabha seats along with 6% vote share in at least 4 states. Now this party is eligible to become a national party. I hope I have been able to clear your doubt. If you have any further doubt, you can ask. It can be in Legislative Assembly or in Lok Sabha. It can be in either. It can be in either. If it is Lok Sabha election, then it can be in 6% in Lok Sabha, or if it is in Legislative Assembly, it can be in Legislative Assembly, because the electorate is the same. Say if the total population of Punjab is 3 crore and the electorate is 2 crores, those 2 crore people are eligible to vote in Lok Sabha election as well as in Legislative Assembly election. So the electorate is the same. The restrictions on UPSC, the UPSC cannot conduct exams for Group C and Group D posts. The UPSC cannot make provisions for the reservation of backward classes, and the UPSC cannot make provisions for the claims of SCs and STs with regard to appointments. These are the restrictions. So thank you everyone. This has been the session on constitutional bodies, and we also covered Schedule 5 and Schedule 6. Let me know in the comment section if you like the session. Thank you.